Make sure to like, follow, and subscribe wherever you guys get your podcasts.
Listen, do what you gotta do to keep us real, okay?
This episode of Off the Cuff is brought to you by Weaver Simmons LLP, Northern Ontario's largest full-service law firm with over 30 lawyers and 60 support staff. For over 90 years, the law firm of Weaver Simmons has proudly served the interests of Northern Ontario residents and has built its reputation based on exceptional services to its clients. For more information about the firm, please visit www.weaversimmons.com. The link is provided in the description below.
Welcome to episode 5 of Off the Cuff. I'm Darren Chohan.
And I'm back, Matt Butler. Did you miss me?
Of course I missed you.
Yeah, of course, man.
How can you not?
Life happens, couldn't make the last recording, but I think you did a great job talking about, real law versus TV law and sort of the unrealistic sort of approach that TV takes the legal practice in.
We see that a lot, eh?
Yeah.
In our work with our clients.
Mm-hmm.
I find myself often having to have those discussions, especially about the whole, let's get this done now.
Yeah.
Right? I mean, do you see that?
I see it all the time, especially like having to explain court availability. It's like, well, can we get this in court next week? It's like, no. Sometimes it takes a few months to get court time.
Well, that's like we were talking in our first episode. You were scheduling things like 6 months out.
Yeah, it's gotten a little bit better, but we're still scheduling things out. So, it was good that you spoke about that, in my absence. But it was appreciated.
Well, I had to make something up on the spot because,
it was good,
I
though.
was without you.
I thought it was excellent. But I'm back. The duo's back. Let's talk about
stuff.
Some neighbor stuff.
Okay. Well, if you've been following along, episode 4, we talked about pirate ships.
Yeah.
A nice, beautiful boat in a tree.
Yeah, treehouse, boathouse.
And a boring fence.
But those boring fences are the most common cause of neighbor disputes.
Yeah. And now we have a dispute resolution method available to us that we found.
Yeah, it was really interesting.
And that we touched on in episode 4. It's called the Line Fences Act.
Yeah.
And so that act allows people to make an application to their municipality and try to resolve fence disputes before they go to litigation.
And it's a very specific type of dispute resolution where it discusses or it sort of outlines issues or outlines resolutions about whether or not a fence ought to be built or whether a fence ought to be remediated.
Yeah, and I'm looking at right now here.
Yeah, I have it too here.
The City of Sudbury description or explanation of the Line Fences Act, and it does a really good job saying, when does this act apply and when doesn't it apply? And so if you're looking at a fence dispute and you want to try to use this dispute resolution method, the Line Fences Act applies in a situation where an owner wants to build a new fence on the boundary line and no fence exists between the properties, or when a fence already exists on the boundary line. And it's important that you understand that it has to be on the boundary line, right? Because that's where the disputes arise.
Yeah.
That needs to be repaired or reconstructed in some way. So the fence dispute lies in either wanting to build a new one or repair an existing one.
Yep.
Okay. And it's important to know before you take any steps of just doing it yourself, which we don't recommend doing, you consult, the Line Fences Act, you consult your neighbor, as there's been a thread throughout both episodes now and will be the thread in this episode, is always consult your neighbor because ultimately you're going to have to go into this project together, right?
Essentially, yeah. And what's the beauty of the Sudbury website that you have pulled up there is that it's very user-friendly for people to look up themselves and to read and really understand it.
Yeah, and we'll put a link in the description below to what I'm looking at because I think it's important if you have, of course we're in Sudbury and this applies to Sudbury, and each municipality will have a different application process and a different cost structure, which is important to know. So if you're watching this from other towns.
Right, we can also put the ontario.ca
that's
link
right.
because that's the one I have here.
That's right.
It's
probably a mimic. I haven't seen the ontario.ca one, but I can imagine it's like
it's solid.
It's a mimic of this one.
Yeah.
And then I'll tell you, actually, while I have this up, the Line Fences Act, when it doesn't apply, and this is important to know too, because if you as somebody who has a problem with a fence, and there's no fence existing on the boundary line, and you want to just rectify it yourself, and you decide, well, my neighbor, because it's on the boundary line, will have to pay 50% of this, no matter what. I'm just going to go ahead and do it myself. The Line Fences Act won't save you in that circumstance. So if you go ahead and do all the work yourself and then just give your neighbor a bill for the half the fence, it's not going to fly unless your neighbor agrees to pay it.
Right, and that was the case we saw during the last episode.
That was the last one we looked at, where the guy just went ahead on his own.
I thought he had an inherent right to have it paid 50%, where that's not the law and that's not the case.
Right, and then the other scenario where the Line Fences Act won't save you is if you and your neighbor can't actually agree where the boundary line is.
Right, and that's something that the municipality won't get involved in.
No.
In this situation, in the Line Fences Act situation.
Right, because the way to go about a fence dispute in the Line Fences Act is that you have to make an application to the city.
Yep.
There's a cost associated with that, so there's a small application fee. And then the process is the city will send out what they call fence viewers to your property.
And they'll send 3.
And I think they send 3, yeah.
They send 3, yeah.
And when those 3 fence viewers come to your property, they will evaluate if the act even applies. And then they'll issue a decision, which is akin to an arbitration decision. They call it an award.
An award, yeah.
And so there's specific things that they have to actually outline in their awards, including an apportionment of the costs, including whether or not the fence needs to be taken down or redone if it's unsafe, or constructed, and we'll apportion those costs appropriately after consultation with all the parties involved, which is where I can't get back to this enough.
Right.
All parties involved.
Yeah.
That does mean you, your neighbor, and what if this fence is like a triangular boundary where there's properties in behind where this adjoins, right? So you have to make sure that it's not just your immediate neighbor. Your neighbors include the 360 radius around you, right? So we got to make sure we're looking at all the stakeholders involved before any decisions are made and undertaken. Anything is spent, any money is spent.
It's also important, they really try to take any guesswork out, where they say the description of the fence, where to be constructed, reconstructed, but also the materials used. So it's not as though the fence needs to be constructed here, you're going to pay this amount, you're going to pay this amount, and all of a sudden you're going, well, who's building the fence, what's being done? So they're really outlining how to go about subsequent to an award. Yeah. Like most arbitrations, there's also an appeal process if you disagree with the fence viewers.
That's
award.
right, yeah. And there's a cost to appeal it, and I believe once you appeal it, that'll start its own process. So for example, if you as one of the parties involved doesn't agree with the cost apportionment, or if you don't agree with the layout of the fence, or the materials used, you can appeal those decisions. And when you're getting into those appeals, we would recommend that you seek counsel. You're going to want to find a lawyer to help you through that process,
or at least advise you on the process. Because from the Ontario.ca website, it does outline that an owner who is dissatisfied with an award has 15 days to appeal, and as of 2022, the price or the fee to appeal is $352. So it's $352 for just to have the appeal process commenced, and you have just over 2 weeks to appeal. So
timelines are tight.
Timelines are tight, and if you want to seek counsel, it's better to do it right away than maybe sit on it for a week, because then you only have 8 days after.
Or if you're really worried and you think that there is a grounds for an appeal, start the appeal yourself, and then get a lawyer involved as soon as you can, because you don't want to miss those timelines. Yeah. Because once you miss the timeline, it's going to be very difficult for you to get back in that avenue of recourse, because you're going to have opposition from the other side saying, well, you missed the timeline. It's done. This is what it is now. So always be aware of that. Look at the act. If you're confused about it, the city has people that can help you through it. They have this process set up internally. So I'm sure that there's a department that you can get a hold of within the city that would assist with this.
Yeah, and the theme of our last episode and this issue as well is that you can contact your municipality for assistance. If you're unsure on what to do, this podcast hopefully can sort of guide you into, avenues of what to do. But also, at the end of the day, if you're fundamentally sort of stuck on an issue, you don't know what to do, call your municipality. They have the resources to at least advise you on different recourses, and they have fence viewers. The city of Sudbury has fence viewers. Municipalities have these fence viewers, so it's important that you contact your municipality to get their input on it, and hopefully they can assist you thoroughly. So potentially you don't need to call one of us. You don't need to call council. Hopefully, in the best case scenario.
Yeah, and it always just helps making sure you have all the facts, talking to the people that are around, that are going to be involved, and that is what eliminates the need for lawyers. When lawyers need to get involved, everybody's costs are going to skyrocket. And time, right? So if there's some critical element of time to this fence going up, like, I don't know, you want to build a pool, and this pool has a certain window of delivery and going in, and you need that fence put up, and then all of a sudden you're caught up in litigation about a fence, and then your pool is delayed, and then you miss it, and with COVID, all of the supply chain issues, it could cause a domino effect of problems for you. So it's always, always good to just get it out there, get the word out there. We say it in almost every episode. The more disclosure, the better, right? I think it applies cross. We practice family law. We say it there. I practice litigation. I say it there. Yep. There's disclosure obligations. There's disclosure obligations for a reason. And to me, that's critical in being successful in what you're doing.
Especially, this is a neighbor.
Yeah.
At the end of the day, if you're having a dispute with the person you live next to, it can get quite ugly, which we're going to get to at the end of this episode.
Right. And remember, after the litigation ends,
so you're going to live next to them.
They're still your neighbor. So that's the piece that you have to really watch out for, is that if you turn into some nasty litigation with your neighbors, you either got to move or deal with it, because they're going to be your neighbors unless they move. And so that takes us to the next stage, which is litigation.
What happens if you got to commence an action?
What do you got to do?
Defend an action.
And at that point, I think we'll take a break here from our sponsor,
take an ad break,
we'll get into the small claims court afterwards.
Good stuff.
This episode of Off the Cuff is brought to you by Weaver Simmons LLP, Northern Ontario's largest full-service law firm with over 30 lawyers and 60 support staff. For over 90 years, the law firm of Weaver Simmons has proudly served the interests of Northern Ontario residents and has built its reputation based on exceptional services to its clients. For more information about the firm, please visit www.weaversimmons.com. The link is provided in the description below.
Welcome back. Now, Darren, I have a question for you.
Do you?
I have a neighbor dispute, okay? I've dealt with this person. They've damaged my fence. I fixed it myself. I didn't know about the Line Fences Act, okay? And now,
you didn't watch our show yet.
I didn't watch the podcast yet.
Okay.
I didn't know about the Line Fences Act.
Okay.
So I fixed my fence. They damaged it. My neighbor damaged my fence. There's a whole bunch of other issues. The music's too loud, and I can't enjoy my property the way I initially was enjoying it. What is my recourse? What can I do?
I got a solution for you.
What is it, Darren?
I don't know, Matt. I think the small claims court is what your probably next avenue of recourse is, because with the small claims court, you have a cap on damages. And for the listeners out there that don't necessarily understand or know what damages are, in the small claims court, you can sue for money damages. And that means the small claims court can award you a sum of money for the problem that you find yourself in, whether that's the exact cost of having to repair the fence that your neighbor damaged. They can also award general damages, which are like, most people from TV know the pain and suffering, right? Or the inconvenience to your life damages. That's like the typical general damages award. And then there's also damages if you're specifically suing somebody, and in your scenario there, if there's nuisance, which is the loud music or if you're suing somebody for trespass. So the small claims court can order damages, money compensation for those different torts. And a tort is a legal wrong.
Right.
And that just means that it establishes that you have a cause of action to sue somebody.
Yeah.
And so a cause of action is trespass, nuisance, negligence. All of those things are what we call causes of action. And you then have to determine, based on your fact scenario, which of those elements of the torts, civil torts, you fall under, and then you sue for the appropriate remedy, and then the remedy is money in the small claims court.
And this cap of the small claims court is $35,000. So if you have an issue that's, you spend about $12,000, you're like, well, where do I commence this? It's in the small claims. Like we said, the cap's $35,000. It was $25,000 about 2-3 years ago. It's been recently, but it's been increased $35,000.
Yep.
And the beauty of the small claims court is that it's meant as a court of expediency.
Yep.
The rules of evidence aren't as strict, and you commence the claim, and hopefully you get a settlement conference relatively quickly, and then in the event that you don't have a settlement, you go right to trial, and it's supposed to be done quickly.
Yeah, and with COVID, things have slowed down a bit.
Sure.
But from what I received a notice actually the other day, things are moving again.
Yeah.
Small claims court is starting back up. It's different in every city too. Each city's small claims court is run a bit differently.
Yeah.
And so certain ones are not behind, certain ones are super behind. So you just got to check with your local small claims court, and the registrars are really helpful. So
yeah, they have been very helpful.
They're very helpful. You can call them up. They're working. They'll tell you when the next court dates are. They'll tell you what you need to file, how to get your claim into the court.
How to serve the party.
Yeah, and they really tell you what you need to do. It's awesome. And the Ontario government has put out guides on small claims court litigation. And so I suggest that you take a look at those if you're thinking about commencing a claim, because they're a really good resource that really outlines the steps you need to take to bring an action.
Yeah.
And if you're successful, there's guides on how to enforce that to get paid at the end, which, it's nice to have a judgment. You want to know how to get paid. That's the end goal of all of this.
Yeah, we'll put a link at the bottom of the...
we'll put a link for the guides, because, with those guides, you may not need a lawyer. It might save you the cost of having to hire a lawyer, especially in the small claims court. If you're looking for $5,000 to repair your fence, are you going to pay a lawyer a $5,000 retainer?
It's difficult. So
it's challenging, right?
Right.
You don't necessarily want to. You're already out $5,000 because you fixed the fence, and then your lawyer's asking you for another $5,000 retainer. That's tough.
Yeah.
But paralegals can represent you in the small claims court, right?
Which is great. You're going to have a paralegal represent you, and truly, because the rules of evidence aren't as strict, and the rules of procedure are very user-friendly. A lot of people find themselves representing themselves, and it actually works out quite well for a lot of people, because if you're in the superior court, and it's a very formal setting, you may get lost in the rules of civil procedure. The rules of small claims aren't as incumbent on strict adherence.
Well, and that's a really good point, because in the superior court, and as you said, it's a more serious court, the judges hold you as a litigant to the standard of almost a lawyer. They understand that there's some
latitude here,
but you are expected as a litigant in the superior court, to follow the rules.
Yep.
And there's very strict guidelines and very strict adherence to the rules that is required and expected of litigants, self-represented or otherwise.
Yep.
But in the small claims court, judges understand that people are representing themselves. The registrar understands that it's mostly people that are representing themselves. And strict adherence to the rules is encouraged, but oftentimes there is leniency given in the small claims court, sometimes much to the dismay of lawyers. Because
it becomes difficult when we argue in these courts, because we
expect a standard of litigants.
Exactly. And we also expect a standard from ourselves, where we want to have these strict adherence to the rules.
And when it's frustrating when you can't force another party to adhere to the rules, and the court is granting all the expediency and leniency that they have the latitude to give because the rules are relaxed. And I find myself very frustrated sometimes dealing with that. But on the flip side, it's very helpful as a self-represented individual.
It's very helpful, yeah.
And I can assure you that a judge will treat you the same, whether you're a lawyer or whether you're self-represented, and will assess the case fairly and give you a result that is just and fair in the circumstances, regardless of your status as a litigant.
Yeah, and to go back to the original point, it was like the majority of neighbor disputes that require litigation, I think, fall within the small claims court.
I would say so. Yeah, I think so.
And so if you do find yourself in a situation where you're unsure, because it's still litigation at the end of the day, you're still going to court. It's still something that can be intimidating, can be a little bit overwhelming at times. You can contact a lawyer or paralegal, and lawyers, some of them offer unbundled services, which means that we can assist in certain steps of the case, whether it be to draft your claim, respond or defend the claim, or even just advise on specific steps, how to gather evidence, how to present the evidence. So you can actually contact a lawyer and they can assist you through those process without representing you from beginning to end, but advising you in specific moments.
That's such a good point, because nowadays people want to do more themselves.
Yeah.
And people don't necessarily have the funds to hire lawyers.
It's expensive.
It's expensive. And we offer that as a secondary service, because if you just need help with one aspect of the case, but you don't want a lawyer to represent you the whole way, that's what Matt's talking about. Mm-hmm. You contact us, we draft a letter for you, or we give you an opinion. You pay us to just give you an opinion on your case, which might help you decide whether to go ahead or not.
Yep.
And that might save you all the money that you're going to expend in litigation or lawyers or just trying to gather your evidence, because at the end of the day, you have to still run a trial if you're not going to settle it with the other party, and you do need evidence.
Yeah.
And evidence gathering, as you'll see in the case that we're about to get into, is so huge and time-consuming.
Very time-consuming. That's one thing that I think people get turned off by wanting to bring claims forward, because sometimes of the time consumption it takes to not only a trial having to take that much time, like whether it be a 2-day trial, 3-day trial, and then I think in yours, the case that we're going to discuss, it's a multiple day trial over a span of a few months. That alone is time consuming. But just gathering evidence, gathering witnesses, getting their statements together, preparing cross-examination of potential witnesses, it's exhausting. For litigants, never mind lawyers. Like for litigants going, we really got to go through all this to properly prepare. Yes.
Yeah. I mean, oftentimes we're preparing longer than the actual trial takes. We have preparation time set aside. For a 1-week trial, we're prepping 14 days. We're starting our whole just trial preparation 14 days. Yep. That doesn't include all of the evidentiary stuff that we want to get into at the trial. Yeah. Right. And so why don't we take a look at this case now? Because I think it's a great case. Good case, transitions well into what we've just been talking about. And we'll put a link to this case below. The case is called it's Grasby and Machado, and it's a small claims court decision out of Kitchener. And this decision took me by surprise. It's a 342 paragraph.
It's a wild
small claims decision, which was a roller coaster to read. So I sat there. I think it's a 42-page case or 40-page case. Sat there, read it all, and what a ride!
It's not just like a little dispute here and there. It's every possible element of contention between neighbors.
Yeah, and there is, I'm just counting here, 1, 2, 3, 5, 6 days of trial.
Over how many months?
From September to April.
Just think of that. 6 days of trial took how long? A few months? Just because the parties were represented and they had to adjourn, and they just couldn't find court time and lawyers' availability. So a 6-day trial over a span of a few months. Yeah.
So as we talked about earlier, you can sue your neighbor for trespass, for nuisance. This case also, the neighbor sued the plaintiff back, and there was a counterclaim, which is pretty common.
Yeah, especially neighbor
disputes. And so they counterclaimed against the original plaintiff for infliction of mental suffering, which is another tort that
has a very high bar.
To
prove, yeah.
And for harassment.
Yep.
And I like to talk about these cases, what the result was, and work backwards. So the result in this case, the plaintiff's claims were all dismissed, and the counterclaim for harassment and intentional infliction of mental suffering, the defendant in the original action was successful in suing the plaintiff, who was the one that had all the issues to begin with.
Right.
She is the one that got torched at the end.
It's it's worth a read if you ever have a lot of time on your hands. It's worth a read.
Yeah, it is. But we'll give you the summary. We'll give you the 411 here.
Yeah, the ABCs. Here.
So you've got a dispute in this case where the plaintiff sues her neighbor for issues with a carport, issues with a fence, issues with a chicken coop, issues with rodent infestation, issues with honking of the horn at different times of the day and evening and overnight, I think she said.
Yep.
And just harassment and nuisance. And so that's all the problems the plaintiff had with the neighbor. And so the neighbor defended all of these claims, and then also brought their own claim to say that this woman's behavior was so egregious that it caused them to have anxiety, depression. They were afraid to go outside. They were afraid to live their lives because they felt they were always being watched.
Right. And the important here, because you said intentional infliction of mental suffering, it's the intentional acts to cause that anxiety.
Yeah.
Which is an important, not just like, I have anxiety. No. This is directly caused by the plaintiff's actions.
I'll tell you this. You want to hear what you actually have to establish?
Yeah, it's a pretty intense test. Go ahead.
Flagrant or outrageous conduct.
Like that alone is a very difficult bar.
Conduct calculated to produce harm or where it is known that harm will ensue, and actual damage is suffered. And
it's incredibly difficult to prove. Let's just outright. That's incredibly difficult to prove.
She was found to be committing intentional infliction of mental suffering on one of the parties to this case.
It's intense.
And she is the one. I can't get over it.
She's the
one who commenced the claim.
She commenced litigation, yep. And she was found that she was intentionally inflicting this pain to the neighbors.
Now, what's even more wild on this ride is that she only got $6,000 for mental suffering.
Yeah.
Think about that.
Kind of like just a nominal figure.
At the end of the day, don't you go through more mental suffering over 6 days of trial?
6 days of trial
and multiple months?
Several months, yeah.
And I didn't even tell you the best part.
Well, tell me about the best part then.
The dispute started in 2014.
When was the trial heard?
2019.
That's 5 years of
harassment, litigation, neighbors yelling at each other.
And small claims where there is sort of let's get the ball moving here. It's a court of expediency.
And this one, you mentioned earlier, had 2 lawyers. So there was a lawyer on each side representing the interests of each party. And it just goes back to the fact where, I said it last episode, I think, encouraging resolution, trying to get out of this litigation. And perhaps the lawyers could have done something different to try to get these people closer. Maybe they couldn't. I don't know. We weren't there, obviously. But encourage resolution. Try to get yourselves out of these disputes because it's just awful. And to finish all of that and to get into a spot where I think their total damages for the harassment and mental suffering for both defendants totaled $13,000.
Yep.
And then the plaintiff got 0.
Yep.
why would you put yourself through that?
It's intense. Like we jokingly said, this is a wild ride. But for these people,
This was their life.
But just the litigation process, the dispute until the trial, that's 5 years of your life where you're in constant anguish. Both parties, the plaintiff, though all her claims were dismissed, I'm sure at some point thought their claims were legitimate, right?
But don't you know the fallacy of the witness? Have you heard of this?
Tell me about it.
If you tell yourself something is true over and over and over again, eventually to you as the person, it becomes the truth.
Yeah. This is what happened in this case, I think, where we found ourselves in a situation where the plaintiff, in this case, was victimized by everything that the defendants were doing, and vice versa. The defendants felt victimized by everything the plaintiff was doing. It was a war. It was a 5-year war. And like, I'm using war in, hyperbole here, but for these people, there was this 5 years of like mental anguish. And it just goes
to what end?
To what end? 13,000. You probably spent considerably more.
Way more than that. And not to mention all the money you spend along the way dealing with fighting, repairs to things.
And this wasn't just where it was like, oh, they provided their evidence and the plaintiff provided evidence and the defendant provided evidence. There were many witnesses.
They canvassed like 7 neighbor witnesses to come forward with affidavits.
Right.
They had to call in people from the city to come testify about all of the bylaw problems that were complained about. They had to call in people that inspected the carport. They had to do all of these things as evidence gathering and witness cross-examination, multiple witnesses, multiple lay witnesses, which is even harder to do sometimes because you're not dealing with experts.
No, you're just dealing with people and their experience.
And you're calling in city officers to testify as pseudo-experts. And there's one issue I really want to get into, which I found was really interesting, and it's the chicken coop.
Yeah.
And so we'll get into that after the break, but we'll take a short break and we'll go into that.
Sounds good.
This episode of Off the Cuff is brought to you by Weaver Simmons LLP, Northern Ontario's largest full-service law firm with over 30 lawyers and 60 support staff. For over 90 years, the law firm of Weaver Simmons has proudly served the interests of Northern Ontario residents and has built its reputation based on exceptional services to its clients. For more information about the firm, please visit www.weaversimmons.com. The link is provided in the description below.
Welcome back. Now, Darren, chicken coops, what you got for us?
I'm glad you asked. I've been waiting for like 20 minutes to talk about this.
Yeah, you love chicken coops.
I know. So this case, we'll get back into that first. The big dispute, the biggest one in this case, was that the neighbor put a chicken coop in their backyard, and the plaintiff thought, first, that the chicken coop was causing a rat infestation.
Right.
And the second was that apparently at some point he had a rooster, and the rooster was waking people up in the middle of the night or first thing in the morning.
Your typical standard thing.
Those roosters, man.
Mm-hmm.
Who puts a rooster in a residential neighborhood? This guy, I guess.
This guy does.
He was not allowed to do that, by the way.
Well, tell us about it then.
So there are rules about chicken coops. This case comes out of Kitchener, and I'll put the link below for this Kitchener bylaw for any of our Kitchener viewers out there. But I'm sure most municipalities will have something similar, or they'll have animal bylaws. So
again, check your bylaws.
Always. The backyard chickens, you need a permit.
Makes sense.
Yeah. You have to be 2.5 meters away from side yard lot lines and 1.2 meters away from rear lot lines. Again, this is a Kitchener bylaw, so just think about Kitchener when we're talking about this. And so when you're placing the chicken coop, you got to put it in a certain spot. And there's rules about feed, where the feed can be stored,
right.
All of the rules surrounding the, feces and excrement. And
it's very specific.
Yeah, very specific, and it's all in the bylaws. So there's actually a sanitation section of the chicken coop bylaw to the point where it tells you have to deep clean your chicken coop 2 to 3 times a year with disinfecting wipes and disinfectant.
Oh, wow.
Manure must be cleaned out daily. Dead chickens have to be disposed of relatively quickly. The floor has to be lined with shavings or straw. Like, this is serious.
Again,
like,
super specific.
This isn't just something where you get an idea in your head and you're like, hey, I'm going to go put a chicken coop out back and call it a day.
They really look out and they sort of, foresee issues that the issues that they've previously had.
Well, that's just it.
Yeah, that's
all
the thing.
of these are always born from an
previous issue. Someone going, we should probably get a bylaw.
We should probably get a rule out of this.
Exactly.
That guy, that was not good.
Yeah.
So let's do something about it. And so this bylaw came into force after the case had already started.
Okay.
And there was also grandfathering parts to the bylaw, which allowed the defendant in this case to defend her problem with the chicken coop. He was grandfathered into allowing him to keep his chicken coop in the way he had constructed it.
Nice.
Because of the grandfathering. Mm-hmm. They weren't so thrilled about the rooster. He did get rid of the rooster, but that was a side issue. But again, it's so funny. Questioned at trial, she says that it was only a few times that it woke her up or bothered her.
Right.
And then, the defendant gives his testimony. He said, as soon as realized it was an issue, got rid of it. Mm-hmm. And so it's just perception is reality.
Perception is reality. Also, imagine had it just been a conversation. Hey, can you get rid of your rooster? It's waking people up. Yeah. As opposed to, oh, now we got to go to trial.
Now I'm going to call my lawyer. He's going to send a letter to your lawyer about the rooster. And this actually happened.
Well, yeah, that's what we're talking about it.
And the best part of this bylaw that Kitchener has is there's a neighbor consent form. So this goes back to what we've been talking about the whole time. If you have a relationship with your neighbor that's not atomic, you can actually give them this form, which I'm looking at right now, and it'll be on the description, that legitimately gives your chicken coop neighbor who's got a business plan in mind that wants to sell eggs permission to put their coop wherever they want.
Yeah. And that's what the form does. It's consenting to, we don't mind that there's a chicken coop back there.
Close, that doesn't comply with the setback requirements.
Okay, that doesn't comply.
It's like it's too close to their fence line.
Right. But, again, the theme, talk to bylaw, talk to your municipality, speak to them, but also talk to your neighbors.
Yeah, because if you have a neighbor that'll just say, hey, I don't care about your chicken coop.
Or if a neighbor goes, actually, I have a real problem with that, then you can potentially avoid many issues with that.
By just moving it 2 feet one way.
Or they're going, maybe there's a bylaw on this and discussing with them.
Yeah. So I did really want to talk about that because...
Yeah, you love this part of it.
Oh, I know.
It's a pretty wild thing, the fact that...
It's great.
Yeah, there's a chicken coop bylaw.
Chicken coop bylaw.
That's so good.
And, my wife always tells me that lawyers, we have jobs because of issues that are born out of problems that are otherwise not, solvable.
Right.
And you get to this stage where you say, well, you have a chicken coop bylaw because there was a problem that wasn't solvable a long time ago.
Exactly.
And this is why we have jobs, because
thank you
of bylaws. So thank you, listeners. But let's get into now. That concludes, that's the really fun part of that case.
Yeah, and the small claims one, we sort of wanted to outline that, small claims, though, the court of expediency and there's, the rules of evidence are lessened. They're not as strict. You still can have a fairly significant trial issues and with the damages being nominal, but still, it's the mental anguish. And I've said that a few times now, but the mental anguish in this case that can really, press on litigants. Now, if the damages exceed or far exceed $35,000, you find yourself in the Superior Court of Justice.
Or if you need a remedy that is not just money.
Right.
Right. So that's like
a
little
small claims court doesn't have that jurisdiction. That's correct.
So that's just an important little legal tidbit is that
in this case they sought an injunction.
In the case we're looking at next.
So this is Dawes versus Gill. So in that case, it's on an injunction where you can't get in the small claims.
Right.
You can't even claim it. In
You
small
can't claim
claims.
it in small claims.
And this one it's a little more significant insofar as the money's concerned, because in this case, the plaintiff was suing the defendant because the defendant was reconstructing a house, and the plaintiff thought that the new construction of the house had sort of messed with the drainage patterns, and as such, the water was being drained from the defendant property into the plaintiff property, and it was causing water damage to a basement. So there was the tort of nuisance because of the water causing issues, negligence because of the constructions of the home, and also they were seeking an injunction, which means that they would, like the plaintiff was seeking that the defendant had to stop the water runoff immediately, and that's what an injunction is, like to force someone to do something immediately or to cease doing something.
Right, and it's important to note that you say negligence, then negligence just means an unintentional act, effectively.
Right.
So negligence is, in this case, they constructed something. They didn't mean for it to cause water damage.
Right.
But it did. And that
exactly, yeah.
the claim against them is for negligence and saying, your negligence caused this runoff problem.
Yeah, and this runoff that then essentially
that was not intentional.
But that caused damages, right? Because that's one of a lot of people think, well, you did this, you did that, and it was negligent. You're going, well, unless you have damages.
Measurable
real damages, then,
you can't establish the cause of action for
exactly.
it. So.
And then similarly to your case, with the small claims case, where the defendants counterclaimed. They counterclaimed for nuisance. They counterclaimed for trespass. They also counterclaimed for malicious prosecution and abuse of process.
Which you see sometimes in these cases, because
in this case, it was the malicious prosecution was that the defendants were claiming that the plaintiffs had tried to get a peace bond as against the defendants. So it became quite ugly. Again, it was reconstruction of the home, water runoff, to a point where people are trying to get peace bonds against one another, and we're claiming malicious prosecution, and
all important claims that have to go to superior court.
Have to go to superior, yeah.
This is like this is all the stuff that gets you out of small claims,
exactly,
and into this more
now
trite litigation.
Let's get to litigation. And like the end result here, after an 8-day trial, is everything's dismissed.
Yeah.
Now think about we spoke about there's like 5 or 6 cause of actions in this case specifically, and none of which were established.
This was also a 40-page decision.
40-page decision. Again, a neighbor dispute that started with water runoff that could have been a discussion, led to an 8-day trial. Again, both parties represented by counsel. 8 days of trial in superior court.
Yep.
To have everything dismissed. And I'll actually read a paragraph from the judge's decision. It's one of the last paragraphs. It's paragraph 170. And it's in a this is, I think, encompasses.
This is the theme of our episode, right?
It is. I love this paragraph.
Yeah.
It is very unfortunate that these neighbors could not have found some way to work this out. Sadly, both sides have incurred significant legal costs and even more significant amount of stress.
Doesn't that just sum up everything we just talked about?
Yeah, we could have done a 8-second podcast on talk to your neighbors.
Yeah.
Be kind, be reasonable, because otherwise this is what you find.
You got a judge telling you that.
Yeah.
And he's the one who had to sit through 8 days of trial on this.
And 8 days of trial, we've spoken about the cost portions. Like 8 days of trial in superior court is not an inexpensive endeavor.
I think you're looking at $100,000 between the parties.
It could,
right?
And that's not being unreasonable.
And that's actually, I think, lowballing it.
Like just in the 100,000 between the two parties is actually, yeah, I think you're correct in saying potential lowball, but it's not unreasonable for that sort of sum to be to be the expense. So I just want to go through a couple of things here. So the plaintiff's
again, though,
2014. That's when the dispute started.
And then 2019 is trial.
2019 again, another 5 years. Another 5 years of this kind of stuff. It really is again.
And that's not abnormal.
No, it's not abnormal. But this is a neighbor dispute. This isn't like something that's insignificant. Like you're living next to these people. So the plaintiff's claim for nuisance was dismissed. So was the claim for negligence, and so was the injunction. Now, in this decision, again, we're going to put the link below. for the decision. There are a few paragraphs that really summarize the law on nuisance. So it's paragraph, I think it's 41. So it has an excellent summary on the law of nuisance. So for anybody who's interested in going, what is nuisance? So you hear this term nuisance. If you want to check out paragraph 41, it actually gives, I think, maybe the best summary.
Better than we can even summarize for you,
Frankly,
really, because the judge goes into really what to look at when you're thinking about these kinds of claims, and we would do it injustice by trying to summarize it. Just take a read of it. It'll take you 5 minutes, but
just the paragraphs itself is fairly quick. And then as well as in the decision, I think it starts at paragraph 54, and it goes for quite a bit. But the law on negligence, but particularly negligence when it comes to neighbors,
right?
The duty of care that you owe to your neighbor, and that's the duty of care is a standard where you owe something to another person. In this case, a neighbor owes a duty of care.
And are you behaving like the reasonable neighbor would in the circumstances? So if you look at yourself in the mirror and say, have I behaved reasonably? And your answer is, well,
if your hesitation, you're going, then maybe you're not.
Maybe not.
But again, and then the defendants also, they counterclaimed. They had a trespass claim. This was like leaving items on the property line or on the other person's property. Again, it may have been trivial to most people, but the defendants it happened so often, and because of the previous dispute, they thought it was a type of harassment, a type of intimidation. That was dismissed. There was a right-of-way issue of trespass. That was dismissed. There was a fence encroachment of 3 centimeters. That was dismissed.
Wasn't there a problem with an outdoor television?
Outdoor television. The plaintiffs had an outdoor television. They brought in sound technicians to make sure that there wasn't an issue with the sound. Again, that was dismissed. There was a security camera issue about trespassing. That was dismissed. The malicious prosecution and the abusive process, dismissed. At the end of the day, nobody won anything. It started as a dispute about water. It led to an 8-day trial where I'm sure at one point the plaintiff or the defendants just wanted a win. I want to win this war. I want to win this trial. And nobody won anything. At the end of the day, you walked away from that trial going, I have nothing but a huge bill.
You know who won?
The lawyers won.
The lawyers won.
The lawyers won.
Because who else won? Nobody.
And we don't want to get too much in the weeds about the cost consequences in Superior Court, but small claims over Superior Court, the cost consequences when it comes are significantly different. And small claims, your cost exposure is fairly limited, but in Superior Court, you could find yourself in a situation where you could potentially pay a large sum to the other side just for their incurring of their legal costs.
Correct.
Which is something that needs to speak if you have a dispute.
At that point, you probably have a lawyer, so you should talk to them about you're going to a trial. There's things like cost insurance. That you can look into if you
speak to your lawyer about that.
Yeah, if you're interested, but at the baseline, you got to check yourself sometimes.
Well, sometimes, and again, we've talked about this a few times now, but the mental anguish is, and I've used that term a lot. I wish I could have had a different one, but that's fine.
It's the truth.
But
that is what it is.
This caused significant harm, financially, I'm sure, and emotionally.
We don't know what the aftermath of these parties is.
No, we don't.
Stuff like this leads to divorce. Stuff like this leads to just nasty things. And
just bitterness. You just live in a perpetual state of bitterness, going home.
You don't even want to go home. Yeah.
It's tough.
Ultimately, somebody moves.
Well, that's the
end. Do you want to do that?
But sometimes, again, if people are going 8-day trials, I think they just want to win.
Yeah.
It's I'm not giving you the satisfaction of me leaving the neighborhood when you're being unreasonable, right? Yeah. That's what these people likely. Again, I'm not saying these people thought that.
But we're just saying in general.
But you could think that.
Yep. I would.
Right?
Yeah, I'd think that.
Right?
Instantly. I mean, I'm not leaving. You leave.
Exactly. And as funny as that is, that could be the case.
It is.
So,
we encourage you guys. Take a look at these cases if you got a lot of time on your hands. I mean, it's a pandemic. You probably do. So I think we can leave you guys with that. and we'll take a break, and we'll get back at you after our break.
Sounds good.
This episode of Off the Cuff is brought to you by Weaver Simmons LLP, Northern Ontario's largest full-service law firm with over 30 lawyers and 60 support staff. For over 90 years, the law firm of Weaver Simmons has proudly served the interests of Northern Ontario residents and has built its reputation based on exceptional services to its clients. For more information about the firm, please visit www.weaversimmons.com. The link is provided in the description below.
Welcome back, guys. Thanks for sticking it through if you've made it this far, which I hope you have.
You better have.
I know, right? We talked about a lot of cool stuff today. Last week when I was lonely and by myself, I told you guys that we've been working hard on this episode, and it's true. We spent a lot of time digging and diving and dunking to get good content and to try to give you guys, the real life perspective of what you'll face. Both with episode 4 and this one.
Yeah.
What you're gonna see, what you got to look out for, and when it goes well, and what can happen when it goes to hell.
Nice. Very nicely done. And that's one thing that we thought was important, because this isn't something that, you read in the news and you just go, I don't care. This is something that you may face. Some of you may have faced it. And it's real life issues. Mm-hmm. It's not something that it's, Pepsi sued Coke. It's like, who cares? You care about your neighbor. You care about, what to do if I have a real life issue with my neighbor. So we really wanted to, to hammer that home, and hopefully, it was informative. I think we really discussed.
I learned a lot researching.
Yeah.
And it's great because these questions come up all the time.
Yeah.
We've talked in the past about getting these types of phone calls, and they come in. They come in a lot. Yeah. And people, it's not that you're being malicious sometimes.
No, it's
just a common issue. So, the biggest thing we can leave with, I think, is check your ego at the door and make sure that you're doing things by the book. Mm-hmm. Talk to the people around you.
Contact your municipality.
And just, work with what you got.
Yep.
And don't be unreasonable, please.
It's a good life lesson.
What's next, dude?
So the next episode, we're going to talk about changes in estate law and wills. And it actually touches our practice in family law. So there have been some changes with regard to wills and, sort of the ramifications of that touch upon family law. So next episode, we'll dive into that. I hope you guys stick around for that episode. I think it'll be very informative, very good to go. And then after that, we'll have special guests in the episode subsequent to that one.
Yeah. Stick around. Stay tuned. I'm Darren Chohan.
I'm Matt Butler. Thank you very much.
See you next time, guys.
The views and opinions expressed in this podcast do not necessarily represent those of Weaver Simmons. The contents of this podcast are strictly for informational purposes and not to be construed in any way as legal advice. If you have an issue that you believe requires legal advice, we suggest you contact a lawyer, and if you do not have the financial means to do so, contact Legal Aid Ontario or the Law Society of Ontario. The links are provided in the description below.
Make sure to like, follow, and subscribe wherever you guys get your podcasts.
Listen, do what you got to do to keep us around, okay?